Buckle up, guys, because today's video is a wild ride featuring not one, not two, but three sovereign citizens causing chaos in the legal system. We start with a familiar face, a sovereign citizen Karen who thinks she's above the law and has a right to travel without interference from the police. From the moment the clip starts, you can sense where this is headed, straight into a disastrous confrontation. She's on the side of the road, arguing with officers, confidently spouting legal nonsense. She probably picked up from some Facebook group. The officers give her clear instructions, but she flat out refuses to comply, escalating the situation instantly. As you'll see, these sovereign citizen encounters never end well because reality and the law don't bend to their delusions. In the end, she paid the price, literally breaking her own window when she wouldn't just step out of the vehicle. This is a classic case of someone thinking they can outsmart the system, only to crash and burn in spectacular fashion. But trust me, this story is only getting started, and the courtroom drama that follows is next-level crazy. Let's dive into the first courtroom showdown and see just how far these antics go when faced with a real judge.
I have my citation from last time. I'm still going.
About citation from last time. Get out of the vehicle. You're under arrest. Plus the fucking window. I don't give a shit.
We jump into the Kansas courtroom where the judge is doing his best to walk this sovereign citizen through the very basics of the legal process. From the jump, the judge is calm, professional, and incredibly patient. Probably more patient than most people would be in his shoes. He explains her right to have an attorney and what it means to represent herself, which is a major decision in any legal case. But of course, in true sovereign citizen fashion, she proudly declares she'll represent herself. This is a huge red flag because court procedures are complex and unforgiving, especially for someone who rejects the system entirely. The judge carefully confirms that she's making this choice voluntarily, ensuring there's no coercion or misunderstanding. This step is critical because later on, she won't be able to claim she was denied her rights. But here's the thing. She clearly thinks this move makes her powerful, like she's about to expose the court with hidden truths. In reality, she's just making it easier for the prosecution to dismantle her arguments. The stage is now set for some truly bizarre sovereign citizen tactics to take center stage.
Okay, we had just called 25 CR 250, State of Kansas versus Sidney Taylor Leslie. Jared Regier for the state. Miss Leslie appears in person and per se. Miss Leslie, is that you?
Yes, Your Honor.
Where's your attorney? Are you going to have an attorney represent you?
I am presenting myself.
You know you have the right to an attorney, to hire any attorney of your choice. If you cannot afford to hire an attorney, you can apply, which I think you've already done, but you did not request an attorney, is that right?
I did not request an attorney. That is correct.
You want to proceed on your own behalf, and you can do that. No one's going to stop you from doing that. But is anyone making you give up your right to an attorney today by any threats or promises?
No.
You understand you can hire, and if you can't afford, you can apply for court appointed, and if you qualify, one would be appointed. Do you understand that?
I comprehend, yes.
You do not wish to have an attorney?
I do not wish to have an attorney.
All right. I will show on the record that you've waived your right to an attorney and that you're going to proceed on your own behalf. So how do you plead then, Miss Taylor, or Miss Leslie, I guess it is. I'm sorry, I'm just saying it wrong. Miss Leslie, how do you plead to count one, interference with law enforcement officer?
A plead would be inappropriate at this time. I'm hoping to request a continuance.
Why would a plea be inappropriate at this time?
Okay, so, Your Honor, for the record, I am Sidney Taylor Leslie, in propria persona sui juris. I am here by special appearance only and not making a general appearance. I reserve all of my rights, remedies, and objections, including, but not limited to, any objection to jurisdiction over my person. I require a continuance in this matter. I intend on filing a subpoena for body cam and cruiser footage. There are facts in dispute on this matter that I'm looking to clear up before the matter can continue further.
And here it comes. The classic sovereign citizen script. When asked how she pleads, she refuses to answer directly, Instead, launching into a rehearsed monologue, she declares she's making a special appearance, not a general appearance, as if that magically changes anything. She also claims she doesn't recognize the court's jurisdiction over her person, which is a favorite line among sovereign citizens. Her language is filled with pseudo-legal jargon that sounds impressive to the untrained, but means absolutely nothing in real law. This is a strategy meant to confuse and intimidate, but to an experienced judge, it's just background noise. What's really happening here is delay. She's trying to stall the process by avoiding a simple plea. The judge, however, doesn't take the bait. He stays calm, keeps control of the courtroom, and asks why she wants a continuance. She says she needs more time to subpoena body cam and cruiser footage, implying there are facts in dispute. This is typical sovereign citizen behavior. Claim there's hidden evidence without ever producing anything credible.
All right, I will grant a continuance for you to obtain discovery, but if you don't know how to do the things you just rattled off, you better have an attorney do it for you. Do you understand?
I understand.
All right. Mr. Aguirre, do you wish to be heard before I pick the date for this?
Your Honor, this does appear to be the first setting since the first appearance hearing before Judge Hart back in June. If the court is prepared to set this matter over for discovery purposes, the state does not object. I'm not sure if the court wishes to set that matter for merely control at this time, but I'll defer to the court on that point if the court will find that the bond is being continued and this continuance is at the request of the defense for speedy trial purposes.
All right, Miss Leslie, you're charged again with interference with law enforcement officers, a Class A non-person misdemeanor, driving without insurance, a Class B misdemeanor, and driving without a license in your possession, an unclassified misdemeanor, as well as failing to register your vehicle, another unclassified misdemeanor. The judge would have gone over these with you at first appearance. You want to go over them again as far as the penalties?
No, thank you.
All right. And you've indicated you want to exercise certain rights that you are entitled to and encouraged to. But as I said, an attorney could certainly help you carry out those rights. And you said you do not want that attorney?
That is correct.
Okay. Well, I'll have the record and the docket notes show that you have waived your right to counsel and that you know what you're doing. Now, then, do you want to set it for trial, Miss Leslie, or do you want to get the records and look at them and then set it for trial?
I would like to have a continuance, perhaps for discovery or an evidentiary hearing if possible.
Well, I can continue it for both those readings.
Okay.
For both those readings, to give you time to get all your discovery, the dash cam, body cam things you were mentioning.
Okay.
And then we can also set it for trial. So when's a good 1:30 trial date, Jim?
Your next one will be September 24th.
All right. You'll need to be back here with all your witnesses September 24th, 2025 at 1:30, and that will be by Zoom again.
Your Honor, if I may just get a little more time due to the fact that I'm going to be submitting the subpoena and I'll need discovery and I need to just review it so that I can have adequate time to present myself for my defense.
Well, that's 30 days. You don't think that'll be enough? How much time are you asking for?
I'm hoping for at least 60 days.
Jen, do we have 60 days?
We have October 22nd or October 29th at 1:30.
Which of those do you prefer?
I would prefer October 29th.
October 29th. This is continued to October 29th at the defendant's request. Is that over your objection or not, Mr. Ricky? I don't remember any objections.
Your Honor, if the court is prepared to set this matter for trial, the state does not oppose that, but the state will be requesting a ruling as to whether or not the bond is to be continued and if this continuance is at the request of the defense.
Court does find this request at the defendant's, and the time will count against the defendant for speedy trial purposes. The matter is continued for bench trial to be heard and to be commenced August 22nd, 2029 at 1:30 p.m. via Zoom. So, Miss Leslie, it's going to be here by Zoom. Right? Be sure you have your evidence ready. If you're going to screen share it, whatever you're going to do, make sure you can do that. And if you need any help getting your discovery or presenting your evidence, you're always able to hire an attorney. And if you can't afford one, apply, but do it well in advance of the trial so that you can get the application completed, returned, and the court can appoint your attorney, and you and the attorney can have time to present your case.
Okay, yes. Your Honor, I did hear you say October 22nd. Was it the 29th that I had requested at 1:30?
You did, so I'll make it October 29th. Jen, you said
Thank
either. You said either, and she picked the 29th, correct?
That is correct, Your Honor.
It'll be October 29th at 1:30. Now, Mr. Regier will be subpoenaing witnesses himself for the state. And if you find out or decide you don't want to go with a bench trial, let him know as soon as you can so he can cancel any of those witnesses that he may have coming in.
Thank you, Your Honor.
You're welcome. And don't forget, you can look at diversion and see if that's an option. You can call the county attorney, but definitely look into that issue of an attorney.
Okay, thank you, Your Honor.
You're welcome. Anything further from the state, Mr. Regier?
Your Honor, if the court is continuing the bond in this matter, I have nothing further at this time.
I am continuing the bond. All existing conditions plus the new ones I've stated on the record today.
Thank you, Your Honor.
You're welcome. And Miss Leslie is excused at this time.
Thank you, Your Honor.
Despite her antics, the judge surprisingly grants her request for a continuance so she can obtain discovery materials. This shows just how fair the court system actually is, even when dealing with someone openly hostile to it. But the judge isn't naive. He immediately issues a strong warning. He tells her that if she doesn't know how to properly handle subpoenas or discovery, she should get an attorney. This is the judge's subtle way of saying, you're in over your head, and this could go badly for you. The prosecution also steps in here, noting that they don't object to the continuance. However, they make sure it's clear on the record that this delay is at the defense's request, not the state's fault. This detail is crucial for speedy trial rules and prevents her from later claiming the state violated her rights. The court takes every step carefully, covering all legal bases, while she continues to play games. At this point, you can already see where this train is headed, straight for messy crash at trial.
We have defendant Jose Elizondo.
Yes.
Mr. Elizondo, you have a motion that was filed, so we will get to that after I take everyone's announcements. I just want to let you know that I do have you here, and I see that you're here, but I'm gonna take the announcements first, then we'll get that heard. All right, so if you can just stay logged in, we'll get you processed through promptly, all right?
All right.
Okay, thank you. All right, Mr. Bishop, we have two defendants with motions, and then we have one defendant set for trial. All right. So the first case set for motion is Jose Elizondo. Mr. Elizondo, if you can please unmute and show your video.
I'm here.
Okay, thank you. So, Mr. Elizondo, you had a pretrial hearing earlier this year in May, and then at that hearing, you had indicated that you had mailed in a motion for a bond, and that was the only motion that you had. And we did not have that here. After the court, and we set your case for a jury trial on August 28th. Then after the date of your pretrial hearing, we received a motion in the mail stating defendant's Rule 91 motion to dismiss for failure to state a claim upon which relief can be granted. Mr. Bishop, have you received a copy of that motion?
Your Honor, and made a response.
Thank you.
I believe he's filed two motions. I've got a motion to dismiss and then a motion, no consent given motion.
The judge takes time to clearly outline all the charges she's facing, leaving no room for confusion. She's hit with multiple misdemeanors, including interference with law enforcement, driving without insurance, and driving without a license. On top of that, she failed to register her vehicle, adding another unclassified misdemeanor to the list. This is a hefty stack of charges for someone who claims the law doesn't apply to them, but it's also a reality check. Her situation isn't about one minor ticket. It's a pattern of behavior. The judge even offers to explain the penalties again, showing how fair and transparent the court process is, but, predictably, she declines, acting like she's above it all. This refusal to engage is a hallmark of sovereign citizen cases and only works against her in the long run. The courtroom remains calm. But you can feel the tension building as trial day approaches. She thinks she's building a case for freedom, but in reality, she's stacking the deck against herself.
Yes, that's correct. All right. So, Mr. Elizondo, if you wish to summarize your argument, you may do so at this time.
Yeah, I just want to know, do y'all enforce the Texas Transportation Code?
No, sir, we're not answering questions. You need to summarize your motion at this time.
All right, well, I just want to add to my motion that according to the Texas Transportation Code, Title 1, Section 502.003 clearly states it prohibits political subdivisions from requiring registration, and my violation was due to registration. So that's all I wanted to add, and I plead not guilty and for dismissal too.
Mr. Bishop, your response?
Yes, I addressed this in my response, Your Honor. The city of Dalworthington Gardens is the political subdivision of the state of Texas. And this registration requirement is not a violation of a city ordinance. There is no city ordinance that requires individuals to register their vehicles. That's state law. And so the defendant is incorrect in applying that statute because it's a state law violation, not a city ordinance violation.
The court has read the defendant's motion to dismiss, and I have read the state's response to that, and the court is denying the defendant's motion to dismiss. I don't see where you prepared an order for me to sign. Let me see.
I did not prepare one, Your Honor, but I will be glad to prepare one.
Okay, if you can prepare one, Mr. Bishop, I will get that signed. I'm writing a notation here. Motion denied. Right. And then we have the second motion, defendants, no consent given. Mr. Elizondo, you may summarize your argument at this time.
Whatever I submitted is what I plead to continue with.
Mr. Bishop, would you summarize the state's response?
Yes. The state's response is in the state of Texas, driving is a privilege, not a right. And by exercising his privilege to drive on a Texas highway or street, he is subject to all rules of the road, statutes, and rules. And so the state does not need his consent for him to be subjected to jurisdiction when he has violated a state law. He's not being denied his rights. Driving is a privilege, and by driving, he subjects himself to the rules of the road and other state laws regarding driving.
The focus shifts to scheduling as the court sets a firm trial date, giving both sides time to prepare initially. The judge suggests a date in late September, but she pushes for more time. Another classic delay tactic, she asks for at least 60 days, claiming she needs it to review discovery and prepare her defense. The judge agrees and reschedules for October 29th, accommodating her request while staying organized. Every detail is logged carefully. This continuance is her choice, and the time counts against her for speedy trial rules. The prosecution stays professional, confirming they'll be ready with witnesses and evidence on that date. The judge even explains how Zoom will be used for the trial, emphasizing modern court accessibility. He warns her to have her evidence ready to screen share, showing just how much flexibility the court provides despite her defiance. The court bends over backward to ensure fairness and due process. It's almost ironic. She rails against the system. Yet, the system protects her rights at every step.